just accepted it.
Yeah, I have a clear version on Thursday. $1.5
Oh yes, yeah.
So
Okay.
is it,
Well, it's,
where is
pardon
it?
me.
Oh, this.
I think it's,
See, this is why I asked the pros. This is why I'm here.
and Matt, for you, we need to let it down.
All rise. The Honor, Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Next case is Cato Corporation versus the Zurich American Insurance Company, and we will hear from the appellant.
Good morning, and may it please the court. I'm Matt Sawchak from Robinson Bradshaw. I represent Cato Corporation and its subsidiaries. If I may, I'd like to reserve 5 minutes for rebuttal. Here, in this complaint, Cato has alleged in detail that the COVID virus itself physically harmed its property. Its complaint discusses scientific studies and an expert report that describe how COVID physically harms property. Now, in view of those factual allegations, which distinguish this case from North State Deli and other cases, the Court of Appeals made two key errors here when it affirmed the 12B6 dismissal of Cato's complaint. First of all, the court violated this court's extensive teachings on motions to dismiss. Even though this case involves a 12B6 motion, the Court of Appeals pierced Cato's factual allegations of physical loss or damage. This court's decisions required the opposite approach. Secondly, the court committed an error of policy interpretation when it decided that the phrase in this policy, physical loss or damage, required tangible alteration. That was the court's phrase of property. That reasoning overlooks, first of all, the or between physical loss and physical damage. That or required the court to give physical loss a unique meaning under this court's teachings on interpretation. Also, the court overlooked other teachings from this court on the interpretation of insurance policies. First of all, this court's teachings required the court to give the phrase physical loss the meaning most favorable to the insured that's consistent with the ordinary use of the term. Here, that meaning is a physical event, and speaking of physical loss here, that meaning is a physical event that makes property unfit or uninhabitable. That's what happened here, and what the complaint alleges in paragraph 90 and 91, where the COVID virus infested Cato's stores and made them uninhabitable. Here, though, the Court of Appeals applied a different definition, as I've said, namely tangible alteration of property. That's a much less favorable definition to Cato, the policyholders, and that's in violation of Wachovia and other decisions of this court. Also critical here is the doctrine of reasonable expectations by the policyholder, as laid out by this court in Grant and Register. Here, Cato had every reason to expect that physical loss would be given meaning here, and indeed a favorable meaning for it. First, the or in the operative phrase, as I've mentioned, and second, the fact that this policy involved actual active removal of a virus exclusion, as is revealed on pages 148 and 150 of the record. Under those circumstances, Cato had every reasonable expectation of a favorable reading of physical loss. Because of those two errors, we would ask that the affirmance of the 12b6 dismissal here be reversed. So let me first address further the variance from the 12b6 standard. Even if the Court of Appeals had been right that the policy here required tangible alteration, Cato made pains in its complaint, especially paragraphs 2, 3, and 87 to 91, to allege a physical alteration of its property. Paragraph 87 describes how the COVID virus adheres to surfaces and says that routine cleaning does not remove that adherence. Paragraph 89 describes further how that's a physical transformation of the surfaces. Paragraph 90 alleges that the upshot, the result of that adherence of the virus, was to make Cato's stores unfit for their ordinary use, uninhabitable, unsafe. All of those allegations make Cato's case different from North State Deli in other cases, because the harm at issue there, as was discussed in the last hour, doesn't stem from the physical manifestations of COVID. Instead, it stems from government shutdown orders. So, as to the allegations I've laid out and others, this court's teachings in Sutton and in Value Health and other cases are very clear. Factual allegations of historical or physical events have to be taken as true, and in fact, read in the light most favorable to the pleader. The Middle District Federal Court's case Novant is squarely on this point. Very similar allegations there, and Judge Eagles denied a Rule 12b6 motion, stressing that Novant had alleged adherence to the surfaces and that despite Novant's best efforts, that there had been physical damage. The court held those had to be taken as true on a 12b6 motion, and it therefore denied a motion to dismiss. Here, though, the Court of Appeals rejected Cato's detailed allegations of physical change to its properties, calling them unwarranted deductions of fact. That was an error for at least three reasons. First of all, these were allegations of events on the ground, not deductions from anything. These are not stated as therefore points or something that derives from something else. That's what's meant by a deduction, what's sometimes called an allegation of ultimate fact. That's not what we're talking about here. That's not what my friends from Zurich are challenging here. Second, nor were these statements in the complaint unwarranted. The complaint in paragraphs 88 and 89 lay out scientific studies and an expert report that show this adherence of the virus to property. So these allegations were factual in their orientation and backed by other points made in the complaint. Third, the Court of Appeals made a further procedural error when it reasoned that the record here did not contain any evidence of a physical alteration to Cato's properties. Here, the court was reviewing a motion to dismiss. So the only record allowed under this court's decision in Sutton and others is the complaint itself, the four corners, and any items referred to in the complaint specifically or attached. Here, that was the insurance policy. Fine. Out of those two, only the four corners of the complaint spoke to what had happened on the ground in Cato's property. So it's unclear to me what the Court of Appeals was referring to as a basis for piercing the complaint. Now, Zurich, in its brief, doesn't directly address these procedural errors, but it does echo them. At some length, pages 18 to 23 of its brief, it joins in arguments that the Court of Appeals seems to be making that Cato's factual allegations are false. That's not the 12b6 standard. For example, my friends argue in their brief that simple cleaning can remove the COVID virus from surfaces. Cato's complaint alleges the exact opposite, factually, in paragraph 87, saying that routine cleaning does not eliminate COVID virus particles from surfaces. Second of all, my friends argue that Cato's allegations are factually false because they imply that property everywhere was harmed by COVID. That's a misreading of Cato's complaint. Cato is alleging that its property was damaged. It is not making any kind of universal allegations. Certainly, Cato was not alone in its losses and in the adherence of COVID to its surfaces. But this idea that there's a universal allegation is not what Cato is alleging. Third, Zurich argues that Cato's property must not have been physically made uninhabitable or damaged by COVID because Cato eventually was able to reopen its stores. And that's noted in paragraph 3 of the complaint. But here, that same paragraph 3 expresses that even when Cato could reopen at first, the virus severely limited the habitability and safety and functionality of the stores. Now, to qualify as unfitness or uninhabitability, there need not be an absolute uselessness of property. Instead, in the cases we cite, the property at issue had impaired function, to be sure, but it still had some limited function. A good example is the Motorists Mutual versus Hardinger case from the Third Circuit that we mentioned in our reply brief. There, a home had E. coli in the well of the home. That was the water supply. Now, the Hardingers still could have used their house, and some of our neighbors in Western North Carolina demonstrated. During this unfortunate time, people are still able to occupy property for certain purposes by using bottled water or perhaps by boiling water if they're able. No one's saying that those houses are perfectly habitable, but also no law requires that uninhabitability depend on total uselessness of the property for any purpose. So all told, this is a case about the facts. The exact degree and duration of Cato's losses isn't a pleading stage issue. That's the teaching of this court's decision in Sutton. But unfortunately, Zurich is asking this court in a 12b6 posture to pronounce as a fact, that's the word used, that the COVID-19 virus does not cause physical harm to property. See, for example, pages 10, 9, 18, and 30 of my friend's brief. But as the court will recognize, those types of that's false arguments are not 12b6 arguments. To the contrary, this court taught us in Sutton versus Duke that a complaint shouldn't be dismissed unless it appears to a certainty that the plaintiff cannot recover under any set of facts that could be proved in support of what's alleged. To the contrary, as this court said 2 years ago in the New Hanover education case, the policy of notice pleading, which is this court's approach, is to resolve controversies on the merits after an opportunity for discovery and not at the pleading stage. But that's exactly what did not happen here because of this complaint being pretermitted by 12b6 dismissal. So here, the Court of Appeals made an error by cutting off this case before those factual debates could be had and that factual record developed. So even if my friends were correct that a tangible alteration were required, and I'd like to now say a few words about why it's not, the Court of Appeals still made a grave procedural error under Sutton and other cases by piercing the factual allegations I've mentioned and dismissing as a result. Here, the complaint, again, took pains to allege a tangible alteration, knowing that that might be the argument that was coming. In a 12b6 posture, under Sutton and other cases, those allegations should have been taken as true. So, a second error by the Court of Appeals here was to misconstrue the policy at issue by holding that it does not cover property injuries from COVID and therefore doesn't open the door to other coverages under the policy. Let me highlight a couple of the key principles from this court that have already come up this morning, but that deserve highlighting as we take up this question of policy interpretation. First of all, as Justice Dietz noted, and as this court has said in ringing language, probably the most important general rule that guides courts in the construction of insurance policies is that all doubt, all uncertainty as to the meaning of the contract shall, this court said, be resolved in favor of the insured. Secondly, this court's decisions call for broad construction of the type of covering terms in insurance policies that are at issue here, like here, physical loss or damage. This court said in Harleysville that it construes coverage extending terms liberally so as to provide coverage, whenever possible, by reasonable construction. Now, Zurich argues that that rule of broad construction is limited to ambiguity situations. But that's not what this court said in Harleysville, and that's not what this court said in the state capital insurance case that Harleysville cited for that proposition. In both cases, a transition was made in the opinion to discuss that rule of liberal construction, separating it a bit from discussion of ambiguity. So as far as this court's opinions have taught me, there is a standing rule of broad construction of covering terms, even in the absence of ambiguity, because I think we're all realistic to know that some amount of interpretation is needed in almost every case of this complexity. Now,
can I just ask you before your time runs out? It seems to me we also have to construe the exclusions portion of the insurance contract, which is appropriate at 12b6 because it's part of the complaint, the actual insurance policy. And so help me understand why the contamination exclusion doesn't apply to your client here.
Thank you, Your Honor. Yes, here the record makes this point pretty clear for us. In the record at pages 148 and 150, Cato actually bought its way out of the contamination exclusion, or I should say the virus exclusion that was contained in the contamination exclusion. What happened there was, first of all, paragraph 54 of the complaint, as I remember, states that Cato actually paid an incremental premium to have the virus exclusion removed. And Justice Earls, the virus exclusion was part of the contamination exclusion here. So what happened was, on page 150 of this amendatory endorsement, the definition of contamination was changed from an exclusion that took out coverage for viruses and instead said contamination is essentially any experience or any impact of a contaminant. The same amendatory endorsement on page 150 goes on to slightly narrow the definition of contaminant, but it's really, in any event, the key event here was removing a contamination exclusion that excluded virus coverage and replacing it with this much more open-textured definition of contamination that had nothing to do with viruses. So I hope I've answered your Honor's question. Now, so as to these principles of
I
interpretation.
think you answered Justice Earle's question, but I'm not
course.
sure I followed that. But so are you saying that the exclusion that's operative now in the policy for this allegation of coverage does not cover viruses in its plain text?
Does the exclusion exclude coverages for virus? Is that
Right,
your
because it seemed to me when I read the one that's actually in the policy that it did consider viruses to be part of the list of contaminants that were the contamination and the exclusion.
The original body of the policy before the effect of the amendatory endorsement does contain a virus exclusion, to be sure. And the complaint alleges in paragraph 54 that Cato bargained for removal of a virus exclusion, and that's what we see in the amendatory endorsement. So if your Honor's question is there in this contract read as a whole, which I think everyone agrees needs to happen, and that would encompass the amendatory endorsement, was the virus exclusion removed? Yes, it was removed, most notably, to Justice Earle's question, by changing the definition of contamination. So,
But a citation in the record says mandatory endorsement Louisiana. What's that got to do with North Carolina?
So a few points about that, Your Honor. One is notice that that is the title of the endorsement, one of several endorsements in the policy. Section 620 of the policy, drafted by Zurich, takes pains to say the titles don't change the coverage, neither expanding it nor contracting it. So that's the answer to that title. Secondly, at worst for Cato, this use of Louisiana creates an ambiguity in the policy because it is not stated, nothing in the text of the endorsement, I mean to say, has anything to do with Louisiana. There's a great discussion of this very same endorsement, specifically using the word Louisiana, in the Novant case from the Middle District that I've mentioned. And really the same endorsement is at issue there, and the same arguments by my friends for Zurich were made there. And Judge Eagles goes down the line and points out the answers to every question that Zurich has about this, noting section 620, noting the fact that there's actually no textual references, and noting that to the extent that there's any conflict among the amendatory endorsements, that's a problem of Zurich's making, requiring resolution in favor of the policyholder. So if the court has no further questions, I think I'd like to reserve the balance of my time for rebuttal so that I can hear what my friend from Zurich has to say.
Thank you, Counsel.
Thank you, Your Honor.
Hear from the Appellee.
May it please the court, my name is Lauren Cooley and I'm here for Zurich American Insurance Company. This court should affirm for two reasons. First, accepting the facts as they are pled, Cato did not allege facts that amount to direct physical loss or physical damage to property as a legal matter, as required for all coverages in this case. Second, even if Cato had alleged physical loss or physical damage to property, coverage is barred by the contamination exclusion in this policy, which explicitly excludes virus. I'll actually begin with the contamination exclusion since that was the focus of the court's questions and then turn back to the physical loss or damage issue. As was discussed in the colloquy with my friend, this court can affirm for the independent reason that the plain text of the contamination exclusion in the body of the policy at 3030101 excludes contamination, and the definition of contamination at R96 expressly includes any condition of the property due to the presence of the virus. The endorsements in this policy set forth changes to the policy that apply to property in particular states. So Cato operates stores in at least 37 states. And in this policy, there are 31 state-specific endorsements to the policy at the back of the policy, and a provision that newly acquired property can come within the policy as well, and that's at record 76. Cato is saying that one of those 31 state-specific endorsements, titled the Amendatory Endorsement Louisiana, changes and removes the word virus from the exclusion nationwide. That is an unreasonable interpretation of the plain text of this policy and the context of this policy for several reasons. First of all, North Carolina law provides that we do not ignore words in a policy, but rather each word is to be given effect if it's reasonable to do so. Cato has no answer for what Louisiana means, or what the state references at the top of these 31 state-specific endorsements would otherwise mean. In their version of the policy, those words serve no purpose and are effectively deleted. My friend cited 6.2 of the policy, which says that titles are for reference only, but that is exactly Zurich's position. These state titles, these state names, these words in the policy, they don't change the substance of the endorsement, but they do provide a geographic reference that tells us which state the endorsement applies to. No ordinary reader reading this policy and seeing all of these state-specific endorsements with this specific language in them would think that an endorsement with a title limited to a particular state actually applies and gives rise to coverage nationwide when the nationwide applicable exclusion expressly applies to any condition of the property due to the virus.
Well, getting back to something Justice Allen mentioned in the earlier case, I mean, it certainly would be clear if it just said this endorsement only applies to policies to the state of Louisiana. And it doesn't actually say that, right? So a reader could think, well, this is the origin of the endorsement, but it applies.
Your Honor, I think the question, sorry, I didn't mean to interrupt.
No, go ahead.
Is what is a reasonable interpretation? And it still is not reasonable to assume that that language has no meaning and to see the structure and the context of this policy, which applies to property throughout the country to many different states, and not understand what those state-specific endorsements are for. In the reply brief, my friend cited 2 of the 31 endorsements, New York and Connecticut, that have another clause in them that specify further that they apply to property in those states. But what that additional language does is simply confirm what we all know the title of the endorsement means. And the other 29 state-specific endorsements, the other 28, are all written exactly as the Louisiana endorsement is written. And North Carolina law calls for reading the policy as a whole, for harmonizing the provisions. So not only would Cato's reading ignore the specific language of the endorsements, it would disregard that structure, the context in which the Louisiana endorsement appears. And it would also create conflicts throughout the policy. So instead of harmonizing the policy, it would render different endorsements in conflict with each other, and there's no answer that is provided for how to harmonize those provisions.
So doesn't Cato allege that it did purchase or pay to have the exclusion modified for its North Carolina stores?
It alleges that it paid to not have a virus exclusion.
Right.
Now, we accept that as true, setting aside that that isn't how these policies are priced with the mandatory endorsements. We don't get to that point and to get to that allegation, get to that alleged extrinsic evidence unless the policy is ambiguous. And here, there is simply no way a reasonable person would look at this policy and not understand that the Louisiana endorsement applies to Louisiana. And there's no connection to Louisiana here. There are conflicts that are created. We mentioned the different time periods to bring suit. In our brief, Georgia has a 2-year period in the endorsement in the policy at record 138, Maryland 3 years at record 152, Missouri 10 years at record 164. That's one example of the type of chaos that would be created if the policy were read the way Cato submits and why it's not a reasonable reading. There are other conflicts, for example, terms for cancellation. There is a general provision for cancellation at record 83. Alaska's endorsement at record 12 sets forth a fee for cancellation by the insured. The Florida endorsement at record 129 says there's no fee for the insured and puts limits on the insurers. Different endorsements have different requirements for cancellation. Zurich's interpretation is the only one that gives meaning to every word, creates no conflict, and is reasonable on its face. And that's why all the appellate courts to have considered this issue have agreed that that is the only reasonable interpretation. The Illinois Court of Appeals in the Firebirds case, the Ninth Circuit in the AECOM case, the Eighth Circuit in Lindenwood, they all recognize it would make no sense to have an exclusion in the main body that is overridden by an endorsement that only references one single state. These broader principles were also recognized by the 10th Circuit and Dino Nobel outside the COVID context, that this is how a person reading an insurance policy would understand a policy structured this way. The Western District of Virginia and the Carillion case, the Eastern District of Pennsylvania and Boscov's have addressed this in the COVID context. The cases that my friend cites, including Novant, those involve situations where the policyholder operated in one state, or they didn't operate in the state at issue at all, and there wasn't at issue some sort of newly acquired property provision. And in the Novant case, that is how Novant has been distinguished by, for example, the Illinois Court of Appeals and Firebirds. The part of the reasoning in that decision, in the Novant decision, is that this endorsement doesn't make sense in this policy because it would never apply to this policyholder. There's no conceivable purpose for this endorsement, and so it's unreasonable to read the policy in that way. We don't have that scenario here. We have a nationwide operation. We have states with different insurance regulations, and so when insurance companies sell a policy like that, they are providing specific terms that bring the coverage for properties in particular states within the requirements of those state insurance regulators. There's no indication here of how Cato's interpretation of the Louisiana amendatory endorsement could be reasonably read to erase the word virus from the plain language of this contamination exclusion as applied nationwide. If there are no further questions on the contamination exclusion, I'll now turn back to the allegations of physical loss or physical damage to property. So turning back to that language has a plain and ordinary meaning. It means tangible alteration or physical loss like dispossession. That is reinforced in this policy by the period of liability provision, which makes clear that there is not property loss or property damage without repair or replacement of the property. The North Carolina Court of Appeals, both before COVID and after the COVID context, has applied the plain meaning of those terms, and it is not alone. All 19 state Supreme Courts that have interpreted this language have recognized that it has a plain and ordinary meaning in this context. Once you establish what those words mean, Cato's claims fail as a matter of law. What their main theory is essentially loss of intended use, or that the allegations, their assertions that there has been direct physical loss or physical damage should suffice. But if we look at the actual facts alleged in their complaint, they are describing not a physical loss, but a loss of use, an economic loss. They've not been physically deprived of their property. So looking at what is alleged in the complaint, Cato alleges that there are virus particles on their property, that they adhered to or bonded with surfaces or air. The COVID was exhaled by people onto surfaces or into the air in their spaces, and then could be transmitted to the next person because it was landing on the surfaces, attaching in some way, being carried through the air. And they say that is physical loss or physical damage to property. But they don't plead that virus particles caused any discernible alteration to property, that it changed the color or the shape, or it broke the property. They don't allege any invisible harm to the property that caused the property to deteriorate or degrade. They don't allege a single item that they had to repair or replace. They do allege that although the COVID virus was, according to their allegations, everywhere all the time, that they reopened to the public when the orders lifted, and that's at record 215. They acknowledge at record 241 that virus particles are gone from surfaces within weeks. And as many courts have recognized, these exact same allegations, these facts, these scientific studies, these descriptions of the way that COVID particles interact with property at a subatomic surface, the mere fact that the virus was on or in the property as a legal matter is not physical loss or physical damage to property. So the upshot of the argument is as long as they assert otherwise, as long as they assert that that is physical loss or physical damage to property, the court's bound to accept that at the motion to dismiss stage and the case proceeds to discovery. But that fundamentally misunderstands the issue on appeal and the issue before this court. The question is, what does physical loss or physical damage to property mean? And that's a legal question of contract interpretation for this court. And then a legal question about whether this set of facts, assumed to be true, assumed that they would be proven, whether that meets the legal definition. And their assertion that it does is a legal conclusion that's not entitled to any presumption of truth.
So suppose that there was flooding, and as a result of that flooding, the store inventory was covered in mud. And where would that, how would you analyze that?
So the covered property in this policy is insured building structures and the personal property within the building. So the inventory would be incorporated in what is covered. If the mud is on the clothes or on the property, there is a tangible alteration to that property.
But suppose that all that's necessary to restore it to a condition that would allow it to be sold would be simply cleaning it.
If the cleaning of the property would, if you just wash your clothes, then it wouldn't be the type of property that would be physically damaged. If I have,
So you would say it wouldn't be covered?
I would say it wouldn't be covered. If I can put like a stain remover, what you just sounded like you're describing. Mud is wet also. Mud, the idea that the merchandise is going to be the same after I run it through the wash, I don't know that would be true. I think that would be a clear candidate for a repair or remediation. The difference here is that whether the virus particles are on the property or not, there's no material characteristic of the property that is changed. What is really we're really worried about is not the effect of the COVID on the property, but the effect of COVID on people. It's not the question about whether the mud is still on the clothes and that damages the clothing. Even accepting their allegations that there is COVID on the surface, it's like fog on a mirror. You might have, as you come out of the shower, your mirror is fogged up. It either dissipates on its own or you wipe it down to accelerate the process. But while the fog is sitting there, you wouldn't say that mirror is physically damaged or physically lost. Another example would be marbles on the floor. You spill marbles on the floor, you might not want to walk on the floor. There might be a risk that you fall if you do that. But you can pick up the marbles, and you wouldn't say that that creates physical loss or physical damage to the floor. The same thing with COVID. There's not something about the property to fix, to repair. If I clean my kitchen because I splatter some oil, I don't have a property insurance claim, even if it took some elbow grease to get the oil off of the stove. That is not in common, ordinary speech, physical loss or damage to property. And North Carolina looks to common, ordinary speech. And picking up on a theme from the prior argument, the consensus of the courts that have looked at this issue, I think, recognizes what ordinary people would say, which is that COVID-19 harms people, not property. We all went through this experience. We've had COVID in our homes, in our courtrooms, in our workspace. We don't throw out the furniture. it is not a threat to property, it is a threat to people. And we know this from Cato's own allegations that they reopened despite the virus being everywhere. We know that grocery stores and hotels continue to operate throughout the pandemic. The property itself is not destroyed. The stores remain intact. The property is in the same condition, material condition it was before and after the pandemic, even though the virus is with us even now. So whatever impact that COVID has, and it has obviously a very substantial impact on people and on our lives, it's ultimately not of a detrimental consequence to property. The Sixth Circuit recognized this early on in these cases in the Santos decision, where it explained the impact on physical property is inconsequential. Now, Cato's use may have been limited by government orders or social distancing, but again, that was done to keep people apart, to keep people from spreading the virus to each other. It wasn't a result of something wrong with the property itself. And that is the case just as if someone sneezed who had the cold or the flu on the podium. We wouldn't say the podium is physically lost or damaged. We would clean it and move on. At least 15 state Supreme Courts have reviewed essentially these very same facts, assumed them to be true at the motion to dismiss stage, or assumed they had been proven at a later stage, and then held that those same facts did not amount to physical loss or physical damage to property as a matter of law, applying the same essential principles of contract interpretation that this court applies, looking to the common ordinary meaning of the words, reading those words in context. Some of those states have reached those decisions at the pleading stage, applying liberal notice standards just like this court. That includes even California, which under their very permissive standard was faced with the same allegations that the virus adheres and makes property unsafe for its intended use. It was in the air. The New Jersey Supreme Court, the New York Supreme Court, the Pennsylvania Supreme Court, in affirming McMiles, all of those states involved liberal pleading standards and recognized that these same facts can't establish coverage. Ohio and Nevada were at a different stage. They're also liberal pleading standard states, but they're holding as a matter of law in all these courts, whatever the standard is that they're applying, the upshot is still the same, that the common sense and ordinary meaning of each word, including physical, read in harmony with the period of liability provision, yields a clear meaning that isn't satisfied by the presence of the virus and property. And no amount of discovery or future litigation will change that COVID hasn't stated a claim for recovery. If they prove all these things to be true, that property is a transmission vehicle, that they had to implement social distancing, that they had limited use of their property, that there was some bonding, we still end up in the same place we are today because they haven't identified a material change to the property. They haven't identified something that in ordinary parlance is physical loss or physical damage. And we can look at how the policy is set up to again tie it back to the physical requirement of physical loss or damage to property. What is called time element coverages covers loss of income if, say, a fire causes a store to close, but first you have to have the base requirement of physical damage to the property. And the policy explicitly says at 411 that it only applies and provides business interruption insurance when there's been a suspension of business due to direct physical loss or damage. It says any suspension for any other reason, just loss or damage, not direct physical loss or damage, is excluded. And that's 3325. And this case, where Cato is describing its loss of intended use as a physical loss, it's describing an economic loss. There's nothing wrong with the property itself, so the business interruption that it claims is untethered to the condition of property. That makes this case different from cases that my friend discussed and that were cited in its reply, largely out of the Third Circuit, where property was determined to be uninhabitable and totally useless, and therefore satisfied physical loss in some sense. What some courts have said is that physical loss or physical damage may exist where there's a physical condition of the property that makes the property uninhabitable or totally unusable until you bring in specialized remediation to restore the property, like friable asbestos requiring a hazmat crew to come in and tear out the walls. In those contexts, some courts have said that that physical condition of the property effectively leads to a physical dispossession. But those same courts, Cato does not cite, have held in this exact scenario, interpreting the same words, reviewing the same alleged facts, that that rule does not provide coverage for COVID-19 because the presence of the virus doesn't do that. The New Jersey Supreme Court, the Pennsylvania Supreme Court, the Third Circuit in the Wilson case, the Fourth Circuit in Uncork and Create, interpreting a West Virginia precedent along these lines, the New Hampshire Supreme Court, the Massachusetts Supreme Court, all of these cases, all of these courts where these cases come from that have recognized this uninhabitability, total unusability, effective dispossession standard, they have each and every one rejected its application to give rise to coverage in this context. And what those courts have held is that COVID-19 is not the same in multiple respects. First, the property is not uninhabitable. It's not totally unusable. There's simply no way to read the complaint to see an allegation that the virus had a physical impact on the property that made it so that the property was totally unusable. Really, Cato says not usable for its intended purpose, but that is not what those cases address. And second, those cases involved physical alteration of property, and they distinguish the COVID context on that basis, where there is a substance emanating from the property, asbestos in the walls, a pipe breaks so the ammonia leaks, the E. coli has colonized the well. The condition of the property is what is creating the hazard. It is not people coming in, exhaling, leaving. People are the source of COVID-19. In these uninhabitability cases, the property is the source of the hazardous condition. And third, these courts have distinguished the COVID context because the virus becomes inert without people doing anything, unlike the property that has to be remediated in order to be returned to a state where people can come inside and use it for some purpose. A few other quick points to respond further to Your Honor's question. Cleaning is not the same as repair. To the extent cleaning is involved, it might speed up the removal, but it doesn't fix the property. It just prevents the transmission. And in the meantime, the question isn't whether the substance is harmful to people or whether it can be dangerous for people to use property, but whether the property itself is tangibly altered or there is a physical dispossession of the property. I'd like to also address some questions that have come up about what the significance is of exclusions when you're interpreting coverage in a policy. Exclusions don't only exist to eliminate coverage, they also exist to eliminate disputes. And North Carolina law is not different in that respect. The Wachovia case from this court that is cited in our brief and my friend's reply brief, it says, to insert a provision that will eliminate even the remotest possibility of litigation upon a given theory is not a recognition of the reasonableness of such theory in the absence of such provision in the policy. That's this court interpreting an insurance policy and holding that you can have a belt and suspenders approach in an insurance policy. It doesn't mean that it's recognizing that there is otherwise going to be coverage or that you otherwise understand plain words in a totally different way than their plain meaning would indicate. The cases that Cato cites, the Vaughn and Fowler cases, they involve situations where there was no dispute there would be coverage, but for application of the exclusion. And so, of course, in those cases, the courts were recognizing that the exclusion eliminates coverage that would otherwise exist, but those courts don't adopt the rule that Cato proposes, which is that's the only understanding that we could have of an exclusion. They cite no case that interprets insurance policy exclusions that way, and it would turn insurance policies on their head and disregard the plain meaning of what the coverage provisions actually state about what is in fact covered. There's no COVID case that has determined that direct physical loss or physical damage to property means something different than we would understand it to mean because of the exclusions that exist throughout these policies. The Seventh Circuit in Crescent Plaza recognized that there was no coverage and that an exclusion applied that provided an independent basis for denying coverage, and cited the proposition that overlapping provisions provide greater certainty for the scope of both coverage and exclusion provisions. The specific version of their surplusage argument applied to exclusions for virus doesn't work even on its own terms, even if you accept that an exclusion could influence the way you interpret the coverage language to mean, because we are considering what a specific virus, the COVID-19 virus, what impact it had on the particular property here, Cato's retail operations. But you could have a scenario where a virus potentially could cause harm to some other type of property, like livestock or plants. The Massachusetts Supreme Court addressed this exact argument and recognized that the virus exclusion isn't simply surplusage because it could apply in other contexts. Cato's reading of exclusions would also be absurd. There are exclusions in this policy for, as I think has been discussed in the context of the Cincinnati policy, for loss from the enforcement of laws or government regulations like occupancy and zoning restrictions. And Cato's interpretation would render governmental regulatory measures, changes in the fire code, physical loss or physical damage to property, and that's not a reasonable reading of what physical loss or physical damage means and is not the reading that any court has adopted. Another example of the absurdity that argument creates is 303.02.02. The policy excludes indirect or remote loss or damage. We know the coverage provision here applies to direct physical loss or physical damage to property. Under Cato's theory, direct physical loss or damage to property actually means indirect physical loss or damage to property because everything in the exclusion has to be covered in their theory. That's absurd. That's not reasonable. That's not what these policy interpretations do. What they do is they eliminate the possibility, would eliminate the possibility in theory of a dispute or reduce disputes over what the scope of the coverage provision means. Cato's interpretation would violate the plain meaning of this policy, disregard words in the policy, and overlook what the ordinary meaning of physical loss or physical damage means. So in conclusion, we respectfully request that this court affirm because Cato, as a matter of law, has not alleged facts that amount to physical loss or physical damage to property, and for the independent reason that the contamination exclusion in this policy applies to any condition of the property due to virus. If there are no further questions, I'll yield the balance of my time. Thank you for your time today.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. My able friend's arguments have highlighted how Zurich is putting itself at war with the factual allegations of the complaint. For example, my colleague stated that COVID, as a matter of fact, that COVID harms people and doesn't harm property. Paragraph 90 of the complaint alleges just the opposite. It alleges that COVID caused tangible, physical transformation of Cato's properties, making them, the properties themselves, unsafe, unfit, non-functional, and uninhabitable for their intended uses. Another point of confirmation, my colleague stated that COVID doesn't remain on surfaces as a factual matter for all that long. Paragraph 89 of the complaint alleges just the opposite. It cites Dr. Rasmussen's report stating that the effects of COVID are not temporary. So these arguments made at the lectern and in Zurich's brief are disregarding this court's teachings in Sutton to take the allegations in a complaint as true and not disregard them unless there is no body of evidence that could prove allegations like those. Now, Zurich is also making an argument of law that what is alleged that I've described doesn't amount to physical loss or damage. We've answered that in our reply brief, but let me highlight a few points. First of all, I draw the court's attention to the Scott Johnson article that we've cited, specifically around page 117. I found it very helpful in my own study of the case. It discusses cases like Motorists Mutual and Gregory Packaging and others, where an external force, here the COVID virus, made property unable to be used, uninhabitable, and the like. And those teachings, as the court construes physical loss or damage, are critical because this court's teachings on policy interpretation say adopt the meaning of the operative language that is the most favorable to the insured. We've obviously got a reasonable dispute between able parties about how that term is to be interpreted. The Scott Johnson article and the cases I've cited, Motorists Mutual, Gregory Packaging, and others, those are reasonable interpretations of specifically physical loss. Also notable is the rule from Grant and Register and other cases about the reasonable expectations of the insured. Here, seeing physical loss or the disjunctive used, Cato had every reason to expect that its policy would be interpreted generously, as the cases I've cited allowed. Now, Zurich has made arguments under the period of liability provision. Let me just say a word about that. Again, under the reasonable expectations doctrine, that is a provision about the duration of the time element coverage. No reasonable, that is to say, saying when it starts and ends. No reasonable policyholder would take a time measuring provision like that as one that changes the substantive meaning of the key covering language of the policy. Footnote 11 of the Huntington Ingalls case from Vermont speaks to that issue very well. Also, my friend's argument is fundamentally COVID could not be repaired. Well, the complaint alleges just the opposite. In paragraph 3, I believe it is, that Cato made efforts to repair and remediate the stores. So if the argument being made is that there's a reviewability condition on physical loss, that's been satisfied here. Repairability condition, excuse me.
Do you accept the distinction between cleaning and repair? That cleaning does not equal repair?
Cleaning, I think that's a factual issue at bottom, Your Honor. I don't think there's clear case law on whether cleaning generally can be a matter of repair.
When I wash my car, am I repairing it?
There may be some cases in which...
if I washed my car, I should say. My car is in desperate need.
I join you there, Your Honor.
But do you think that most people would understand that to be a kind of repair?
Probably most people would not. But the difference would be the state of your and my cars is not fundamentally a pre-existing situation of physical loss. Here, Zurich is arguing sort of blowing through the other end of the straw, as it were. It's saying that because in Zurich's opinion, the property was not repairable, there never was a physical loss in the first place. As I've said, that logic really doesn't work very well in reverse, partly because of the time orientation of the period of liability clause and its purpose and reasonable expectations of the policyholder. Finally, one more time about the contamination exclusion in the last minute that I have. The mandatory endorsement in question, page 148 of the record, starts with these words. This endorsement changes the policy, not the policy for Louisiana losses, not anything about Louisiana. The policy. Please read it carefully. Several other of the mandatory endorsements, New York, Connecticut, California, say something about one state. Again, I commend the court's reading of the Novant decision from Judge Eagles, which goes absolutely down the line of the same arguments Zurich is making here in a the court reverse the Court of Appeals decision in a 12b6 posture, pay attention to the factual allegations of the complaint, and follow its own teachings to us in Sutton and Value Health. Thank you, Your Honor.
Thank you, counsel. Clerk.
All rise.